panel discussion for the symposium will be on education, training, and networking. This discussion will focus on the programs available at each of the respective institutions of the panelists and or organizations. And it will also include a discussion on networking opportunities. We will now introduce the education, training, and networking panel. Our first panelist, Ms. Charisse Anita Brown, is CEO and Senior Legal Counsel of the Cobb Bahamas Development Company Limited, or DEVCO. She's an associate member of the Chartered Institute of Arbitrators and presently serves as chair of the Education Committee in the Bahamas branch. Ms. Brown received an LL.B. honors degree from the United Kingdom and was called to the Bahamas Bar as counsel and attorney at law on February 28, 1992. An advocate for gender equality through her role as treasurer of the International Federation of Female Lawyers, or FIDA. She is passionate about advancing the status of women and girls in education, civic life, politics, and in the professions. She has served as past president of FIDA, the Cobb Bahamas chapter, and former council member of the Bahamas Bar Association. Retired Justice Rubie Nottage is a retired justice of the Supreme Court of the Commonwealth of the Bahamas Family Division, and is currently an associate professor in the law department of the University of the Bahamas, where she has lectured in ADR, mediation, and arbitration in the UWI LLB law program. In January of 2018, Justice Nottage was engaged by the University of the Bahamas to develop a Master of Laws LL.M. program in the Department of Law. She is a fellow of the Chartered Institute of Arbitrators, UK, and a founding member of the Chartered Institute of Arbitrators Bahamas branch, and a former director of education and training for the Cobb Bahamas branch. She is currently a Chartered Institute of Arbitrators approved faculty member and accredited Carb mediation assessor and moderator. Justice Nottage has acted both solely and jointly with arbitrators of international repute in a variety of ADR matters. Her vision is of a Bahamas recognized worldwide for its talented and experienced pool of ADR professionals in various national sectors, working both domestically and internationally. Sandra Friedrich is the director of the White and Case International Arbitration Master of Laws graduate program at Miami Law's International Arbitration Institute, and also a lecturer in law. Previously, she practiced law at Latham and Watkins in New York, focusing on complex commercial and investment arbitration proceedings, as well as related litigation. Ms. Friedrich has taught courses on drafting complex arbitration clauses, transnational litigation, and international arbitration with a European nexus, international business transactions, European Union law, and German law at the University of Miami School of Law. She has also co-authored several publications on international commercial and investment arbitration. Professor Loukas Mistelis is the Clive Schmidhoff Professor of Transnational Law and Arbitration at Queen Mary University of London, the former director of the School of International Arbitration and director of the QMUL and UNIDROIT Institute of Transnational Commercial Law. He teaches international commercial arbitration, international investment dispute settlement, energy disputes, and ADR on the LL.M. program, and is academic director of the QMUL LL.M. program in comparative and international dispute resolution. He practices as an arbitrator and expert in arbitration proceedings from his own boutique consultancy firm, Mistelis and Haddadin. He is chairman of the court at the Cyprus Eurasia Dispute Resolution and Arbitration Center, and a member of the international board of the Tehran Regional Arbitration Center. He has been on the ICCA panel of arbitrators, as well as on the panels of many other arbitral institutions, and has extensive arbitration experience. He's also a fellow of the Chartered Institute of Arbitrators. And our final panelist, Ms. Lucy Reed, joined Arbitration Chambers New York in January 2020 as an independent arbitrator, following several years in Hong Kong and Singapore as head of the Freshfields International Arbitration Group, and then as professor of practice and director of the Center for International Law of the National University of Singapore. Ms. Reed is president of the International Council for Commercial Arbitration and a vice president of the SIAC Court, having formerly served as president of the American Society of International Law and vice president of the ICC Court. Ms. Reed specialized in international commercial and treaty arbitration in private practice and has sat as an arbitrator in over 50 cases, including as commissioner of the Eritrea-Ethiopia Claims Commission. While with the U.S. State Department, she served as the U.S. agent to the Iran-U.S. Claims Tribunal. Ms. Reed is a New York qualified lawyer and was educated at the University of Chicago Law School and Brown University. For the first question, we would like to give each panelist 2 or 3 minutes to briefly give a very high-level overview about their respective organizations. Ms. Brown, you can go first.
My colleague, Kenya Nottage, gave an excellent overview of Cobb Bahamas and what we are doing at the national and local level. So I won't reiterate that. I just want to add that Carb is the world's leading qualifications and professional body for dispute avoidance and dispute management. There are over 16,000 professionals worldwide, and it's based in 149 countries. 41 branches. Of course, the Bahamas is one of those branches, and the focus is on training of ADR professionals and maintaining professional standards, providing networking opportunities, career development, and support. And certainly at Cobb Bahamas branch, the training of the ADR professionals is something that we see as key if we are going to provide the human resources to staff and support the arbitration hub. Mr. Campbell, I can stop there so that others can give a general overview, and then we can come back to the specific training.
Okay, thank you, Ms. Brown. Justice, would you like to give a brief overview of the University of the Bahamas?
Thank you so much, Mr. Campbell. And thank you for having me address one of the hats that I wear. The University of the Bahamas realizes that ADR and particularly mediation and arbitration are very important in the training of our young attorneys. So in the Bachelor of Laws program, which is a 3-year program, these 2 subjects are offered in the 3rd year of the LLB as options. So the students would have the right to choose either both or one of these 2 out of the 5 options that they must take in their 3rd year. We have a very active group of young arbitrators to be who have joined CIArb, Carb, and so I think coming out of UB, there should be a whole new generation of arbitrators and mediators. ADR is taught as well as a separate course, and a number of persons are involved in that. That's at the LLB stage. The most exciting information that I would like to share with you is that, as Mr. Campbell said, about 1.5 to 2 years ago, I was invited to draft or prepare research an online LL.M that would take approximately 18 months for the applicant to achieve a Master of Laws degree and to have such an LL.M available to persons who have a previous degree, but not necessarily an LLB degree. We felt that this was a way of growing talent in our Bahamas so that many persons who are qualified as financial services personnel or wish to be further educated or gain knowledge in maritime affairs and arbitration and mediation, they would have the opportunity of moving from their previous degree, which might be in English or history, and taking an 18-month course, an LL.M course, in one of these specialty areas. So these specialty areas are the 2 that I'm going to address this morning, arbitration and mediation. And as I've said, this is structured, these two courses will lead to the LLM, but over a structured 3-level ascension, as it were. The first level of about 4 courses can be taken within the first semester. You can exit at that point with a postgraduate certificate. If, however, you wish to move on and improve even more or go more deeply into the particular subject area of arbitration or mediation, another 4 courses must be taken, and you would exit, if you wished, at that point with a PG DIP, postgraduate diploma in arbitration. The final 3rd year is for those or would be achieved by those who wish to complete the LLM. And the Master of Laws in arbitration or mediation will demand a thesis at the end of that year, which must be published in a journal, an arbitration journal, which the University of the Bahamas will begin. As you can see, this is our way of beginning to really saturate our population with persons who have become trained in arbitration or mediation. This LLM does not permit you to practice law. It is not for the practitioner to go before the bar of the Bahamas. It will simply supplement an already achieved expertise. As I've said, it may be in financial services, or it may be in the civil service that one wishes to add arbitration or add mediation and the expertise gained in the LLM to your already achieved educational and institutional knowledge. And so I just want to leave that with you because we're very excited. At this particular point, it's only a proposal that must go and be approved financially by our college council, university council. And so we're hoping that this course, the masters will come on stream, if not September of 2021, then definitely in January, that's a year from now, in 2022. But we're very excited because we feel this will make a great impact in the ADR community. Thank you.
Ms. Friedrich, can you briefly expand more on your role at the University of Miami Law School?
Yes, thank you very much about the opportunities in international arbitration at the University of Miami School of Law. Miami Law, of course, is prominently positioned both academically and geographically for the study of international arbitration and ADR more broadly. As many of you will know, Miami is a major center in international trade and finance at the crossroads of the Americas and with major ties to the rest of the globe. And it also has established itself as a center for international arbitration proceedings. Actually, the latest surveys have it as the 2nd busiest seat in the United States for international arbitration proceedings. And Miami Law specifically has a long-standing tradition of the study of arbitration law going back all the way into the 1950s. Back then, the focus was mostly on domestic arbitration. But of course, since then, we have expanded that significantly into the area of international arbitration and ADR more broadly. We offer 8 graduate law programs, LL.M programs. All of them usually can be completed in 1 year. And that includes, of course, our distinguished White and Case International Arbitration LL.M program. This program, under the guidance of Carolyn Lamb of White and Case, provides a unique educational opportunity for a very small group of students from all around the globe who would like to acquire in-depth knowledge on the international, both commercial and investment arbitration as a platform for either launching or advancing their careers in the field. We have a very diverse class of students. We usually have about 50 students in the program from all around the world. Regularly, we have over 35 countries represented, and usually, nearly all continents, of course, except Antarctica, sometimes Australia, but not always. Our program is open both to US trained attorneys and foreign trained attorneys. And also we have a mix in terms of the experience level in our program. So we have recent law school graduates, junior lawyers, but we also have more experienced practitioners and junior arbitrators in the program as well. Our faculty is quite renowned and is composed of international arbitration practitioners and academics, including, for example, Meg Kinnear, the Secretary General of ICCA, Jan Paulsen, who is our Michael Klein Distinguished Scholar Chair Emeritus, and also Professor Albert Jan Vandenberg, just to name a few. Our students are able to choose from a wide range of international arbitration courses, both focusing on commercial and investment arbitration, and also some of the niche areas like maritime arbitration, for example. And they're also able to take other courses in ADR, domestic arbitration, mediation, negotiation, and so forth. And they also have an opportunity, if they would like, to take basic American law courses together with our JD students, such as contracts or evidence that might also be quite useful in the study of international arbitration. Most of our arbitration courses have significant practical components. So we focus heavily on the practical training for the students' future careers. So we offer simulation courses of arbitration proceedings, courses on drafting, on oral advocacy, on legal writing, and so forth. And we also have a very popular practicum program, which is kind of like an internship for academic credit, with many of the law firms and institutions in Miami and beyond in the area of arbitration. We work, for example, of course, with White & Case, which is the sponsor of our program, but also DLA Piper, Hogan Lovells, Reed Smith, just to name a few. And we regularly place about a dozen students per semester with these firms to work alongside the practitioners and to hone their practical skills. And then, of course, we also have an International Arbitration Institute at the university under the guidance of Jonathan Hamilton of White & Case. And the Institute really is an embodiment of Miami law's long-standing tradition of the engagement with the law of arbitration and strives to progress in the field through research. For instance, the LL.M. and Institute every year host the annual White & Case International Arbitration Lecture, which actually is coming up in 2 weeks. This year, we will be welcoming virtually for the first time David W. Rifkin, of course, the former president of the IBA and a partner with Deborah Voice in New York, and he will be speaking on post-pandemic arbitration. That's just an example of the various lecture events that we're offering as well. Thank you very much. I will leave it there. There's, of course, much more to say, but I know that we are limited in time.
Professor Mistelis, you are a professor at Queen Mary and a member of a number of other organizations. Can you give us a brief overview, please?
Thank you very much. I'm delighted to join you, albeit remotely. I'm sure, given the way Europe has got, it'd be much nicer to be in the Bahamas, but there you go. Queen Mary is a college of the University of London, is an award, a degree awarding institution within the University of London. And arbitration at Queen Mary and the School of International Arbitration is the oldest arbitral institution anywhere in the world. And our LL.M. program is also the oldest program anywhere in the world. We've been in operation since 1983, providing a full program in arbitration. And the School of Arbitration was inaugurated in 1985. As a result, Queen Mary is also having the largest full-time faculty, tenured faculty. While a lot of other institutions rely on adjuncts and practitioners, I think we are perhaps the only institution that has 7 full-time professors in arbitration, as well, of course, as a number of adjuncts. The Queen Mary program is effectively 4 different programs. We have the longest established program is the London-based LL.M. program. And then we have a Paris-based LL.M. program out of Queen Mary premises at the University of London Institute in Paris. This is a separate program which is run a bit more on an executive basis, and is offered by the same London faculty, but there are a few different courses. Then we have our online LLM program. We have actually had for many years a distance learning diploma, going back to 2003, but now we have a full-fledged distance learning LLM, or rather, best said, online LLM. And finally, we have what we call a flexible LLM. Queen Mary works with Sorbonne, with the universities in Singapore and Piraeus and other places. So you can have a flexible program where you can take constituent elements in different parts of the world. As a result, we have, as part of postgraduate education, effectively all courses you could think of: commercial arbitration, construction arbitration, investment, shipping, IP. We have courses that cover ADR, decision-making, negotiation, and of course, in all of these courses, there's the whole range of practical and academic components. Although, of course, we take the view that we are primarily an academic institution, and all of the more practical parts is part of what we call an executive education, which is offered partly in parallel. And for us, it's important that our students have a real-life experience of how the arbitration world operates. And therefore, we have had for the last 36 years a joint program alternating between the annual lecture of School of Arbitration, which is sponsored by Freshfields, and for most people known as the Freshfields Lecture. Lucy Reed was one of the lecturers. We have had 36, and the first time this year was virtually. We have a regular event with WIPO, with the World Intellectual Property Organization, has been going on for about 8 or 9 years. And we have regular events with ICCIT, actually on the 3rd of February, the day of the Miami lecture, but not at the same time. We have a Stockholm Chamber of Commerce, ICCIT and Queen Mary event on investors' perceptions on ISDS reform. I think I would stop here because I think there's more people to talk.
Thank you, Professor Mistelis. That was very, very good. Ms. Reed, you, as president of the International Council for Commercial Arbitration, can you tell us more about that organization?
Certainly. Thank you for having me on behalf of the International Council for Commercial Arbitration, which we call ICCA. ICCA's 60 years old now. It was founded in 1961, interestingly, in the midst of the Cold War, to promote the use of international dispute resolution across borders and legal cultures. We are now a membership organization with about 1,100 members from 90 countries. And I'll mention that the membership dues are modest and we're open to all. We're particularly proud of the young ICCA organization, which has more than 7,000 members around the world. This is to promote international arbitration practice by those young, for our purposes, under 40. And Ms. Nottage has been one of the great leaders of young ICCA. Now, to be very clear, ICCA offers no dispute resolution services at all, or any formal degrees or certificates. We exist to provide education, training, and networking around the globe. And we do that through 4 main categories of activities. The first is we have a biannual Congress. That's been happening since 1961. We've been in Miami. The next one is in Edinburgh, in COVID, of course, and Bahamas, I mentioned. Second category is publications. ICCA is really the pioneer and leading publisher of international arbitration materials, specialist materials, now through kluwerarbitration.com. These include the ICCA yearbook on court decisions on the New York Convention, there are now more than 3,000 covered in the yearbook. We also have the ICCA Handbook, which is a from 80 separate jurisdictions. We have the Congress series, which of course is a book, which presents all the Congress papers, which generally are broken down into half theory and half practice. And we have a very, very well used book called The Guide for Judges, which is a guide to the New York Convention for National Court Judges. Third category of activity is special projects. We collaborate usually through member task forces on front burner issues in arbitration. Most recently, they have included cybersecurity, third-party funding, issue conflicts in investor-state arbitration, and data protection. An ICCA task force is now finalizing an electronic tool that systematizes damages, finding of damages in international arbitration, which is going to be quite helpful. And the current ongoing projects are on diversity, in particular gender diversity and other diversity now, and the very hot topic of the right to an in-person hearing versus a virtual hearing in some 85 jurisdictions around the world. That will be published as an ICCA report. That's a quick run through. Thank you.
Thank you very much, Ms. Reed. For our second question, again, for all the panelists to hopefully get a opportunity to answer, what kind of impact do you think your organization or background can have on advancing ADR in the Bahamas? And anyone can take a stab at it first.
Perhaps I should just jump in here. I'm quite a hybrid because I attended Queen Mary in London. Mr. Berkulis, I think, was my, is it Berkulis? So I also attended an influence of the importance of having ADR taught, and taught not just for the purposes of sitting as arbitrators, but as a community. I think we're very much in need of that expansion of ADR. I'm encouraged also that once persons know of the sort of education of those who sell to either get their training online. At the present time, that's the only way you can really do it. But it's another opportunity for both legally trained persons as well as non-legal. So I think we stand as, we are standards that I think others can learn a lot more from. And the university is trying to be that standard as well.
I would just say, as I said before, that ICCA, particularly young ICCA, provides almost endless networking opportunities, long distance and in the future in person. So we would hope to see more participants from the Bahamas. And one of the other things that ICCA does is the Judiciary Committee, which is now chaired by Albert Jan Vandenberg and Meg Kinnear again, gives judicial roadshows on implementation of the New York Convention for national courts who ask and who wish to have such a visit and set of intensive seminars.
I'd like to make two comments. I think one can only have an impact in Bahamas in partnership with local institutions. And I think that's critical. I mean, Queen Mary has done over the years a number of programs, for example, with the Cairo Regional Center. I think we set up courses there in 2006, and now they run themselves. So we don't have to do that. We've done similar courses in the Thai Ministry of Justice for Court of Appeal judges. We have done courses in Sri Lanka. We have done work with the Ministry of Justice in Japan for the promotion of ADR and ADR education. I think the networking and mentoring that Lucy has mentioned is critical. Justice Rubie Nottage is absolutely also very critical in what she says. Is a matter of interaction, sort of properly. It's not just once saying what is the best standards, but actually how the standards can work best for the region. One final point I wanted to make is one of the hallmarks of Queen Mary is a series of empirical researches we've done about 11 or 12, talking to the business community. Ultimately, it is for this community to adopt appropriate dispute resolution clauses and to support the dispute resolution. The lawyers are beneficiaries, but actually the real users are commercial parties. And I think that's where a lot of work needs to be done.
I want to echo the importance of networking and the professional growth opportunities that I think all of our programs have to offer. I think it's important to connect the new generation of arbitration lawyers and ADR practitioners with more established academics and practitioners in the field. I think mentorship is something that is hugely important and beneficial to younger practitioners. And I think that LL.M programs can certainly play an important role in that. And I think also specifically with regards to Miami and the Bahamas, I think that the fact that we're so closely situated, really right next to each other, it's important to connect practitioners from both sides of the Atlantic here, because we can elevate the region as a whole. We're very closely geographically, so I think elevating the larger Caribbean region, I would say that of course includes South Florida as well, is something that is beneficial to all of us. So having concerted efforts to highlight and to promote arbitration in this area of the world, I think is something that is hugely beneficial. Thank you.
I'm very encouraged about the unified approach that I'm hearing for networking, for mentoring, for the global reach, for the mixture of the persons of seniority with persons who are fairly new. Where Carb is concerned, I just wanted to briefly state that the founding members of Carb, 1915, were made up of an interesting mix of attorneys, architects, accountants, so on and so forth. So we have a wide range of occupational backgrounds and academic disciplines. And I'm hoping that the participants who are watching won't think that we're just limited to lawyers or the judiciary. We have a wide range. Our current chair is an architect. Our membership includes a person of the cloth, medical doctor, so on and so forth, civil engineers. And so we would like to encourage persons who are non-lawyers to also join in. Where Cobb Bahamas is concerned, we embrace members from many, many varied backgrounds, which will endeavor to ensure a rich tapestry of an arbitration reach or ADR reach. Thank you, Mr. Campbell.
I want to echo what everybody is saying. National Bar Association ADR section would certainly be interested in partnering and leveraging the relationships and opportunities available in pulling in diversity in the mediation and arbitration space. Different subject matter experts can certainly add a richness to the experience of ADR. Thank you.
I just want to piggyback on what Kenya has said and to explain the pathways to membership in Carb. The beauty of becoming a member in Carb and training in Carb is that you can start without any previous experience. You can have previous experience, in which case you can be exempted from some of the modules. But there are pathways to membership in Carb. And there are various methods of ADR that Carb introduces. Mediation, construction adjudication, of course, international arbitration and domestic arbitration. I just wanted to focus just for a moment on international arbitration and just go through the stages very quickly. There are 3 modules in the international arbitration pathway. And if Mr. Campbell is able to pull that up for me. We start with the introduction to international arbitration. It just gives an overview of the procedure and practice of international arbitration. The assessment is done online and it's by multiple choice. And at the end of that particular course, you're eligible for associate membership in Carb. And I just want to say that Cobb Bahamas will be hosting an Introduction to International Arbitration course on the 5th, 4th, and 5th of February. And that will be led by our very own retired Justice Rubie Nottage. She will be the course presenter for that international arbitration course, Introduction to International Arbitration. So we look forward to having some of the persons on the webinar participate in that. I will put an email address in the chat so that you can get further information and contact us if you are interested in that course. The next level and the first module is the law of practice and procedure. And once you've completed that module, you are entitled to apply for membership in Carb at the member level. The second module is the law of obligations, and I'm going through very quickly in the interest of time. And that covers the principles of law of contract and the law of tort in the context of how disputes may arise and may be resolved. The third module is the award writing module, and I call this the meat of the course because at the end of the day, the candidate should be able to write a final, reasoned, and enforceable arbitration award in compliance with UNCITRAL model law. The next step and the final step is the peer review, and that is done by an experienced fellow of Carb. And I'm pleased to say that Cobb Bahamas has 6 fellows at the moment. And that number is about to increase because we have 9 persons who recently completed this international arbitration pathway that I'm going through now, and they are anxiously awaiting their peer review. And so Carb is doing quite a bit at the local level to ensure that we are training our ADR professionals and ensuring that we are on the local, national, as well as international level. Thank you, Mr. Campbell.
Thank you so much, Ms. Brown, and to all the panelists. I know I thoroughly enjoyed and learned a lot from this enlightening conversation with you all imparting your knowledge and wisdom. We have a lot more questions we would love to ask, but unfortunately, due to our time constraints, we got to leave the discussion there. Thank you again to all the panelists for taking your time. We are extremely grateful. We hope to have